Hello and welcome everyone for this World IP Forum session to mark the World Intellectual Property Day. First of all, I want to thank the World IP Forum, Naveen and Jeet, for the invite and putting this marvelous program together. Let me get straight to my presentation. My topic today is performance rights and copyright issues. Like in all areas of law, copyright law has faced many challenges both in the industry and in judicial interpretation in its application. One of the areas that copyright law has a lot of challenges is this performance rights feature of it. Now, performing rights or performance rights are the right to perform in public. Large part of this is dealt with by the music industry, as well as a large part of it is also dealt by the film entertainment industry. Now, what is public performance has been defined and interpreted by many judicial decisions across the world, and different standards have been set for different types of public performances. In this presentation, I'll try to explain those differing interpretations which applies to different spheres of music and film entertainment industry and others. I'm also making a special focus on the key modern day issues on public performance. What about by, yes, obviously the online or the internet era and the social media. But first, let me have a look at a legislative interpretation of what public performance is. Now, since I come from Sri Lanka, I thought I will take a look at the Sri Lankan law relating to this. So in Sri Lanka, what is a public performance is defined under Chapter 2 of the Intellectual Property Act number 36 of 2003. Chapter 2, Section 5 states public performance means it divides it into three areas. In the first limit says, in the case of a work other than audiovisual work, the recitation, playing, dancing, acting, or otherwise performing the work in public, either directly or by means of any device or process, is a public performance. So this in short would mean, or it would have meant to cover live performances. In the second limit says, in the case of audiovisual work, the showing of images in sequence or the making of accompanying sounds audible in public, this is generally meant to cover the public performances in fixed performances of some kind of a medium. Now, when it comes to sound recordings and public performance in Sri Lankan law, the Sri Lankan law goes a little bit away in the third limb of this section and says, in the case of a sound recording, it becomes a public performance when it makes the recording sound audible at a place or at places where persons outside the normal circle of the family and its closest acquaintances are or can be present, irrespective of whether they are or can be present at the same place and time or at different places and times. And also it adds the fact that where the performance can be perceived without the need for communication to the public within the meaning of the definition communication to the public. Now, what does this long section means? In simple terms, it means a sound recording becomes a public performance where the performance can be perceived other than by your close family and friends without the need for it to have being falling under the definition of communication to the public. Now, for that, for proper complete understanding, we will have to look at what is communication to the public definition. Now, communication to the public is defined in the Sri Lankan law as a transmission to the public with or without wires of the images or sounds or both of a work, a performance of a sound recording in such a way that members of the public may access them from a place and at a time individually chosen by them. So what are we talking here? We are talking basically of broadcasting of some way, some form of broadcasting. So we are talking of two types of public performance. If I were to go back to the top, there is live performances and recorded performances, meaning something that is fixed in some kind of a medium. Now, why I gave you this definition is to understand what the legislators try to mean by public performances. Now, when I did some search, I find that this type of interpretation or closer to this type of interpretation is what is being given for public performance in many countries across the globe. So you can just take this as an example, legislative interpretation. However, situations of public performances are not that straightforward, and judicial decisions stepped in across the globe to help and shape what public performance mean and give more clarity to differing situations where it applies. Okay, so beyond this presentation, I will be looking at on these differing situations where how public performance is interpreted and accepted and applied. First, let us look at this area of public performance, that is playing music in hotel. Is it a public performance? Now, this is a question that has come up several times. Now, when you say playing music in hotel here, I'm referring to recorded music. Okay, in this particular case, I'm going to refer a few cases here. In this particular case, there's an olden case in Canada, Vignees versus Canadian Performing Rights Society. The question was if copyrighted musical work, this is sound recording, performed on a coin-operated gramophone placed in a restaurant under the arrangement between the owner of the gramophone and the owner of the restaurant for his customers to insert coins and play their song, does that amount to a public performance? Why this issue came? Because the vinyl record companies which sold those gramophone records sued the restaurant. The court held in this case, I'm not going to details of the decision, but I'll go to the judgment. The court held in this case stating that license from copyright owner was permitting the manufacturer of vinyl records only the license for selling, and that does not by itself give the purchaser of record to use it for the giving of a public performance. Therefore, it was wrong for the restaurant to allow its customers to insert coins and play their songs. The songs were there. They could have bought it and just play, but not making a performance through another person for which they charge and for which they had not paid the copyright owner. That was not permitted when the record was brought by the restaurant. That was the reason. Another case on almost similar lines in India, which is a somewhat recent case about 10 years ago, Indian Performing Rights Society Limited versus Dabashis Patnaik and others. In 2007, the defendants were owners of hotel, which the plaintiff confirmed was playing music at their hotel premises in violation of the copyright processed by the plaintiff, without making a payment of the licensing fee. Plaintiff was a performance rights society who has the right to collect royalty. Now, the issue before court was whether they should give a permanent injunction against the defendant and also award damages. The court found in this case that the plaintiff had the right to collect the licensing fee. That was clear. The court held no person would have any right to undertake a public performance or communication with the public or work without a license from the plaintiff, who, as the holder of the exclusive rights in these works, can be the only person to license it. The court gave a permanent injunction against the defendants, restraining them from playing music at their hotels, and awarded compensatory damages also. So in both cases, the hotel or the restaurant was liable. Here, the Performance Rights Society stepped in. In the earlier case, I think probably at that time, Performance Rights Societies were not there. The owner stepped in, and you can't take basically music on a recorded format, in whichever format you take, and perform it to the public in commercial venues. That's the whole idea. Commercial venues where you make money out of that commercial venture, and where you don't pay performance rights to persons who are rightful copyright holders. Okay. Now, a different turn is taken in these two cases. The question in these two cases were whether the question was whether songs played in radio in public places, is it a public performance? Now, what happened here? In the 20th century music, in this case called the 20th Century Music Corporation versus Aiken, a question arose whether a song which was licensed to a radio station to broadcast, if someone, for example, in a restaurant owner, used the radio transmission and amplifies it for public to hear in a place like his restaurant, can the restaurant owner be liable for music copyright infringement for public performance for profit? Like in the previous case, same argument was brought. The argument was the song's copyright holder had licensed it only for the radio station to broadcast. The court rejected this argument in this case on the ground that the radio's broadcast amplified in an establishment was not equivalent to a performance but a passive transmission of songs that a radio station is already licensed to play, and it did not constitute public performance. So if you're amplifying a radio transmission as we've seen in most of the small restaurants or hotels, it does not amount to public performance. You don't have to take public performance license. You may have to take radio license, whatever, but not public performance license from the copyright owners of the song. Similarly, in another case, Broadcast Music Incorporation versus Claire Boutiques, 1991, the difference was the department store, not a hotel, a department store, took similar radio signal and amplified it through their PA system and distributed it to 750 locations of their branches. Question was similar. Question was whether the chain store owner is liable for music copyright infringement for public performance for profit. The US courts settled this in their interpretation here and held that similar to the previous case on a similar vein, and stated that secondary use of the transmission by turning on an ordinary receiver, radio receiver, in public is so remote and minimal that no further liability should be imposed. So the department store owner was also not liable here. What he did also, or she did also, was take the radio signal, amplified it, and distribute among his network. So the people who owns the copyright for the music has already paid for a radio license, or the radio station pays for whatever they are broadcasting. So just because you take that signal and rebroadcast through a PA system, it does not amount to public performance, and liability should not arise. Right, now we come to another area. That is karaoke, as they call it in Japan, or karaoke performances. Now, in a Japanese case, the Japanese Supreme Court made a landmark decision. This is called Club Cats Eat Singing at a Karaoke Lounge, Third Parties Branch case. And the appellant had installed in their snack bar equipment, that is karaoke equipment and tapes, in which copyright in the music and recording belong to the Japanese public, the Performance Rights Society. The bar hostesses and employees would encourage their customers to choose music from the karaoke equipment and sing along to the music. The respondent claimed that this infringed its rights of performances in the music under the Japanese copyright law. Now, the issue before court was whether the karaoke bar had infringed the respondent's right of public performance in its music through their customers singing the respondent's songs. And the court went deep into this, and thus the court held that the singing by the customers was deemed to be under the management of the karaoke bar and was equivalent to the karaoke bar themselves singing the music and songs. As such, the karaoke bar infringed the respondents' performing rights. Now, although fees were paid to the respondents for the karaoke bar tapes, the court held that this was for the reproduction of the copyrighted music and for it to be freely replayed. But the stressing point is this: but singing by the customers accompanied by karaoke was a completely different manner of using this copyrighted material. Therefore, the court held singing to karaoke music amounted in this case to an infringement of performing rights of the respondents, and thus the karaoke bar needed to obtain the respondents' consent, that is performing rights license, to use this music in a way where their customers would use those music for karaoke singing. So if you just play the music that you brought, in this case, it is fine. But with the music that you paid and bought, if it is being used by your customers for singing, right, using the karaoke system, then it amounts to a public performance, is what the Japanese Supreme Court says. Let's take this further into further situations of venue liability. The next two cases are deciding on: is venue owners liable for authorizing the infringing performances on their premises? Now, all this time, the venue owners were considered either they are liable or not liable for public performance by their own acts. Now, in these cases, they are going to look into the situation whether the venue owner is liable for authorizing the infringing performances in their premises done by somebody else. In the Australian Performing Rights Association Limited versus Coolman and Anchor Supreme Court, Australia and New Zealand, the issue before court was, were the defendants liable for the unlicensed performance of musical work by the band on their premises? Thereby, were they liable to the plaintiff for authorizing the infringement? The court held that whether or not the defendant had authorized the infringement by third parties was essentially a question of fact. The court noted that the premises were under the control and management of the second defendant or his servants, and that the second defendant was conducting a public performance, which consisted both the playing of music and dancing to such music. Therefore, the club proprietor was held liable for permitting and impliedly authorizing the unlicensed performance of rights holders' music on his premises by the band or the club patrons. Okay, so they facilitated the situation, was the basic, in the shortest argument I can put. Now, another case in Australia, Australian Performing Rights Association Limited versus Metro and George Putty. This case, the Australian Performing Rights Association is called APRA, sought a declaration that the respondents had infringed its copyright in a number of musical and literary works and sought order restraining the respondents from performing those works in public. The respondents denied liability, contending that they were not aware and had no reasonable grounds for suspecting that any performance would be an infringement of copyright. The respondents acknowledged the need for a license, but contended that this was the responsibility of the promoters of the performance, not them, and over whom they had no control. The respondent also contended that they did not permit or countenance infringing performances. So the issue before the court was whether the respondents, the venue owners, were liable for authorizing the infringing performances on their premises or not. What happened in this case? So the court in this case agreed with the plaintiff, holding that the respondents, Metro, knew or had reason to anticipate or suspect the infringing performances. The court further explained and held that the respondents had the power to prevent the infringing performances by not allowing it or by insisting in advance that a license be obtained by the promoter, and also had some duty of control or interference, by which they meant was duty to ensure that a license was in fact obtained or and continuing to facilitate the performance. Though there was a clause in the contract with the promoters that disclaimed responsibility for seeking licenses for performances, as defendant received notice from the APRA that a license was required, the court held its knowledge that unauthorized performance were taking place or going to take place in its premises, and its failure to take action under the circumstances made them liable. Now, the next thing is in film screening, soundtrack. Is it public performance? This is an interesting case. A lot of issues came up. Now, this is in Singapore, the Performance Rights Society of Singapore versus United Artists Singapore Theatres Limited. Now, the first plaintiff, the Performance Rights Society, was the owner of the rights of public performance. The dispute arose from their screening of two motion pictures, a very famous Jerry Maguire and Titanic. Plaintiff alleged that 3 of the musical works had been synchronized or incorporated into the film Jerry Maguire, and 6 were incorporated into the film Titanic, and they had been synchronized to the Titanic film. Plaintiff did not deny that the United Artists had obtained the license to screen the motion pictures. However, the plaintiff alleged that United Artists' screening of the 2 films infringed their rights, as the screening constituted a performance of their musical works whose sound recordings had been synchronized into the soundtrack of the 2 films. Now, the issue before court was whether United Artists required a licenses from the plaintiff, that is a Performance Rights Society, for a performance of the musical work through a screening of films whose soundtrack had embodied the musical works belonging to the Performance Rights Society, even though the theatre, that is United Artists, had secured public screening rights from the film producers. So what happened in this case? The court held that the screening of the 2 films amounted to a public performance of those musical works. In it, prima facie constituted an infringement of the plaintiff's rights to public performance in the musical works, for which a separate license from the musical works owner are needed. Right? So here, remember, if you are incorporating any song, any song that is separate, somebody may have a license to a film. And if the songs are released, now what happens is, and I should take a little bit away from this and explain this. What happens is songs are sometimes good songs are incorporated into film soundtracks, or songs are made independently for that film itself and incorporated into soundtracks. But different people, record labels and different companies have rights for that song per se. And those rights are given to different countries across the globe. That is the royalty collective rights of the songs are given to performance rights societies across the globe. Sri Lanka, India, all these places, those rights are given. So when you incorporate or synchronize those songs with some record label or somebody else has the same, it's incorporating the same soundtrack, the same sound recording into same sound recording that is being sold as a single or album. If you're incorporating it to a music, the soundtrack of a film, and if it is performed, if it is screened, the screening people will have to take performance rights license for those songs from the Performance Rights Society. Is this judgment? My point is, unless otherwise, the producers of the film and the record label who have independently produced the songs or has independent rights of them has a differing agreement between them and which can be produced. Okay. This is a very important area which gives into not only performance rights, and so many copyright, entertainment law, right related issues across the globe. It happens this part of the world, in Asia as well. Now, I discussed so many areas which are, exemplary from different situations. But let me go into what we call a three-part test on public performance. That is, how to identify whether something is public performance or not. A three-part test which is created in the Telstra Corporation Limited versus Australian Performing Rights Society case. This is a very important thing. It can be used as a guidance for public performance principles, despite we have interpretations by legislature. In this case, Justice Kirby referred to the three broad principles relevant to the characterization of public performance. Now, what are they? Let's go slow and then you will understand. Whether the performance is taking place in a domestic and private setting. The presumption is that if the performance is taking place in private, then it will be a performance Okay. Firstly, whether the performance is taking place in a domestic private setting. The presumption is that if the performance is not taking place in a private setting or in private, then it will be a performance in public. The question applied here is were the people who made up the audience bound together by a domestic or a private tie or by an aspect of their public life. Okay. Now, the second part of the test is whether the performance occurs as an adjacent to a commercial activity. That is, the presumption here seems to be that if the performance takes place in connection with a commercial activity, it will be a public performance. That's the presumption. Now, the third limb in the test is whether the third limb in the test is whether the audience form part of a copyright owner's public, which means if the nature of the audience is a group which the copyright owner would contemplate as being part of his or her public for the purpose of earning royalty, then it is likely that the performance is in public, right, or a public performance. The emphasis is here on the relationship between the audience and the copyright owner, and whether the copyright owner would be entitled to expect payment for the performance of the work. That is it. So this three-part test created by Justice Kirby in the Australian case is a very important case. Test Telstra Corporation versus Australian Performing Rights Association created this. Justice Kirby created this test. It's a very important test. I would advise anybody to keep that in mind because it's easy to apply this test and come into a conclusion. Now, let us go to another area. Now, let us go to another area which has a lot of modern day issues. It is obviously the online and internet era. Okay, now let us go to an area in modern day has a lot of issues. Obviously, the internet and online issues. With people virtually living in a virtual world with smartphones and smart devices, gone are the days you would physically buy a music product, as everyone downloads music to their smart devices. So there are several areas that has created problems, and I'm going to discuss two of those major areas that deals with public performance online. What are those two? The two areas are whether streaming music. Okay, what are those two? Those two are whether streaming music or downloading music, is it a public performance? The second one is online posting your performance by someone else a public performance? Let's first deal with the first two. Now let's first deal with the first one. What is that? Whether streaming music and downloading music is a public performance or not. Now, US courts recently held that the download of a digital file containing a musical work is not a public performance of the underlying work. Therefore, that online music vendors need not obtain or pay for public performance license for their distribution of their and their customers' use of digital music files. Right. So it's held in a US case or United States versus American Society of Composers, Authors, and Publishers. Was the case. Now, going a little bit deep into the case, just to find out why why and how this reasoning came out. Now, in this case, the ASCAP, that is the American Society of Composers, Authors, and Publishers, claimed that the individual downloads count as public performances, stating that downloads are public performances and each download would serve to increase the rate of royalty owed to the copyright holder that are licensed through ASCAP. Now, Yahoo and Real Network were opposing, disagreed, citing that downloads involve reproduction and distribution rights and not performance rights. A court reasoned out their ruling in this manner. Now, they give a very broad interpretation for what is streaming and what is non-streaming as well. And this is really important for you to understand the difference between downloading and streaming and the public performance rights associated with that. Now, in this case, the court said, I quote, a stream is an electronic transmission that renders the musical work audible as it is received by the client's computer temporary memory. This transmission, like a television or a radio broadcast, is a performance because there is a playing of the song that is perceived simultaneously with the transmission. In contrast, downloads do not immediately produce sound. Only after a file has been downloaded on a user's hard drive can he receive or can he perceive a performance by playing the downloaded song. Unlike musical works played during radio broadcasts and stream transmissions, downloaded musical works are transmitted at one point in time and performed at another. Transmittal without a performance does not constitute public performance, unquote. So what did court say in short? Downloading per se is not a performance. But because downloading happens at one point and performance happens at another point, because we have to play it again to perform. So playing, we will see whether playing at another time obviously is a performance, but downloading per se does not constitute public performance. However, the court also noted in their footnote that a transmission could constitute both stream and download, each of which implicates different rights of the copyright holder. This reservation also expressed by the court is very crucial for the distinction between streaming and downloading. Now, the requirement that to be performed by transmission, the work must be transmitted in a manner designed for contemporaneous perception by the listeners. Now, what does that mean? A download is simply, as I said earlier, a download is simply transfer of electronic files containing digital copies from an online server to a local hard drive. So downloading per se is not public performance. Why I repeated this is to say that, but transmission would constitute both streams, that is live streaming and downloading. What happens in that situation is that the part that it streams is considered a performance, because a stream renders the musical work audible as it is received by the client's computer's temporary memory. You don't have to download. While it streams, you can hear, right? This is called contemporaneous perception by the listener. This transmission, like television or radio broadcast, is considered a public performance. Also, you have to understand, going a little bit further, if you want to produce an audio-visual recording of a performance to be streamed, that requires a synchronization license in addition to a public performance license. A synchronization license, commonly known as sync license, gives the producer of the audio-visual recording the right to record the musical work in time relation to the visual images. The Performing Rights Society cannot issue such licenses. Sync licenses are only available from the publisher or the copyright owner. However, once a sync license is obtained, the performing rights license situation is the same as for audio-only recordings of a non-dramatic work. Okay, so that's something a little bit away from performance rights you have to remember. Now, is online posting of your performance by anyone a public performance? What is the answer here? Now, unless it is safe to assume that no one outside your immediate family will ever receive your Facebook post or tweet or your blog post or your YouTube video or something, or your live stream, which is not at all a reasonable assumption, you should assume that posts you make on the internet will be deemed as public performance. A rule of thumb you have to keep in mind. This is because legally, as explained in the common definition above, public performance is defined in the case of a work that is a recitation, playing, dancing, acting, or otherwise performing the work in public, either directly or by means of any other device or process. I go with the words by means of any device or process. A device or process means simply you capturing from your smartphone or similar device any such performance and uploading it or live streaming it. This clearly amounts to public performance. Now, the fact that you own copyright of the recording is a different thing. And also similarly, in the case of you make a video with sounds, not capturing someone else's performance, but you make it, then as per the definition I said in the beginning, it is an audio visual work, that's a video with sounds, and if you upload the video or live stream it, it amounts to a public performance. So what you need to be careful here is not uploading a video that you have copyright to or live stream it, provided you have the copyright to it. But what you have to be careful is when you are recording from a smartphone or a similar device someone else's performances, that is a work that is a recitation, playing, dancing, acting, or otherwise performing in the public, and uploading or live streaming such recording. Here you will have copyright, like I said earlier, here you will have the copyright to the audiovisual work you created, but there will be several underlying copyright issues in the recitation, playing, dancing, acting, or otherwise performing the act you are capturing. That is, for example, if it is a playing of some musical composition, the copyright of the composer, rights of the music being performed, rights of the performance, and the right to record and distribute a recording of the performance, copyright of play if it is a theater act, copyright of the book or publication if it is a recitation of a book or publication, etc., etc., etc. Whole bundle of rights will come up. So many rights of this nature will be held obviously by different people or someone else. All these rights you could be violating if you just use your smartphone and capture a performance of music, recitation, playing, dancing, acting, or otherwise being performed. Now, similarly, even if you are just capturing, say, someone in the streets doing a performing act, although none of the copyrights may be violated, except performing rights probably, you could be also violating the privacy of the person depicted, right? So you need to be careful in doing that. You have to listen to this whole thing. You should keep in mind there's a difference between performance rights and performance rights. The performance rights, which we have not discussed here, are the different set of rights that a performer, a musician, actor, etc., has in their performance over and above that of the author of the work. These are economic rights and moral rights both. That's a different set of rights. That's my presentation on performance rights and copyright issues. Thank you so much for taking time off and watching and staying with me throughout the presentation. Well, I said this last time too. Again, I'm saying this time. I expected last time for the next World Intellectual Property Forum to be held as a physical one so that all of us could meet. But due to the COVID restrictions, it couldn't. But this time, once again, I'm hoping that our next World Intellectual Property Forum could be a physical one where everybody could be present so that we can interact more with each other as well. Thanks again, Naveen and Jeet, for putting this very valuable online conference together to mark the World Intellectual Property Day, falling on the 26th of April. I'll see you soon, and best of everything for the rest of the program. Stay safe and stay blessed. Thank you.